An employee is a person who is employed or engaged to work for wages in exchange for wages by another person. So it's a very broad concept. So as long as someone is engaged to work in exchange for pay or for wages by another person and then works under the control direction of that person, that is an employee.
Who is that person the employee is working for?
Usually we will call them the employer,
right?
But it could be an individual, it could be a company, it could be Haki FM, you know. Yes. So depending on what you've been engaged to do, you're obliged to discharge all of your duties as per your contract or as per your engagement. You're entitled to work in the best interests of your employer. You're obliged, for example, to not disparage the name of your employer. You have to keep certain confidentiality obligations. So if you're working in a space where you're dealing with confidential information or data, you should keep that confidential. The obligations of an employee are quite vast and they're quite broad. Yeah, so there are a few different categories or types of employment. So firstly would be what is called a permanent or open-ended employment, where you're given a contract that says you start on this date, but it doesn't specify that this is the end date of your employment. So the relationship goes on into perpetuity or until the contract is terminated, by reason of what is stated in the contract or by reasons of what are provided for under the law. So this would be usually called a permanent and pensionable or open-ended or permanent. Yeah. The other type of employment would be a fixed term or fixed duration employment, where you can be engaged to work for a duration of time that is specified, like 6 months or 1 year. So you're given a contract that specifies you work for a period of 1 year, and at the end of that 1 year, the contract just ends automatically. And you could agree on any period. It could be 1 month, 2 months, 1 year. It depends. But that contract will specify the date when it ends automatically, and it just expires or it lapses at that time. There are also casual types of employment or casual employees. These are employees who are engaged to do, what we call out here kazi ya mkono, or short-term casual engagements. And what we say or what the law says is that this is the kind of employment where you're engaged to do something that it's expected that you won't finish it within a duration of 3 months. So maybe it's work that you do within a month, it's done, or on a daily basis. You come in, do casual work every day, you paid at the end of the day, you go home, or every week. But then it's work that should not take more than 3 months. If it takes more than 3 months, the law presumes that it's no longer a casual employment. If you have done work on a casual basis for a period that exceeds 3 months, and this happens a lot, you could find people who are employed as casuals for even years and years to work. The employer should convert or should engage you at that point as a permanent or as a different category of employee. But if they don't do that, the law already automatically presumes that you are engaged as an employee and no longer as a casual, and the law will allow you to enjoy the minimum benefits that are prescribed under law. So, for example, you should be entitled to leave, and if you are not being allowed to take leave, then at the point when that relationship terminates, you can go to court and claim pay for your leave days that you never got to take. You should have things like NSSF paid on your behalf. You should have things like NSSF paid, so you'll have an entitlement at that point to sort of approach the court or even your employer and just say that, look, this is the right that I had. I worked for you as a casual for 2 years. I should have been entitled to leave at that point, maternity leave, paternity leave, that kind of arrangement. So the law says that for general employees, the standard working hours or the maximum working hours would be 52 hours in a week. And a working week is 6 days. So you take 52 hours divided by 6 days. That is the maximum number of working hours. But beyond that, the working hours are also regulated by your contract of employment. So you could have hours that are perhaps less than that, remembering that that is a maximum. And so if you work any time above your stipulated working hours, you're supposed to be paid overtime as an employee. Now, that is what the law says. How much should overtime be? Overtime pay should be 1.5 times your usual salary, prorated for the period, or depending on how much extra hours you've put in. The overtime should be 1.5 times your standard pay if it's on a usual day of work. But if it's like on a public holiday or on a day that you're supposed to be on off, the overtime should be double payment. So you should be paid overtime if you work overtime. What is a minimum? Minimum wage is the least amount of money or payment that an employee, should be paid in Kenya, or, because we're talking about Kenya in the context of the country. So minimum wage is just, it's just the plain meaning of it. It's the lowest amount which the law requires an employee to be paid. And this varies depending on your occupation, depending on the occupation of the employee. It varies depending on the location of work, different cities. And I think currently the minimum wage or the lowest amount is around, I think, 15,000 shillings 200 for general domestic or general laborers like domestic workers, nannies, housekeepers. That's the lowest, 15,200. As to whether it's applied on the ground, that's an entirely different conversation. But at least from the law's perspective, that is the minimum for Nairobi and for the major cities in Kenya. Statutory deductions are certain contributions or remittances, or just to use the word deduction, that are made from an employee's salary, and this would include things like the first one that we all like to object to or to complain about is tax. So everyone who's employed will pay income tax or pay as you earn tax. That's an example of a statutory deduction, because it's a deduction from your salary that is prescribed by law. We also make contributions to, like, the NSSF, the National Social Security Fund. Contributions are made to the National Hospital or Health Insurance Fund, and these are mandatory deductions. So that's why we call them statutory deductions. Those are the examples. There's another one, I think, to the National Industrial Trading Authority, a small amount of, I think, 50 bob per employee. So those are the examples of statutory deductions in Kenya. Great. How many days of annual leave you have in a year? Minimum, again, is 21 days. As we've said, what the law deals with is minimums. A lot of people might give more days than that in a year, but the minimum should be 21 days of full pay as your annual leave. There are several different kinds of leaves. So there's what you've mentioned, which is annual leave. And then maternity leave is absolutely different. So in Kenya, every employed woman is entitled to 3 months in a year or just say 3 months of maternity leave, exclusive or in addition to their annual leave, right? And that maternity leave is with full pay. And then there's paternity pay for the men, which they are entitled to, I think it's 2 weeks of paternity leave, again with full pay. Another type of leave that has been recently introduced is adoptive leave, where if an employee is adopting a child, you're entitled to take 1 month off as pre-adoptive leave in addition to your annual leave days, and you take this time with full pay at your employment. I think that the first thing to always keep in mind is that a contract is signed by two parties, and one party can therefore not go ahead and change the terms of that contract by themselves. So an employer is not entitled to change the terms of your employment midway without consulting you, without seeking your consent. So as an employee, you have a right to push back on that. And usually these issues will come up where, as you say, they're not changing the terms positively or in a way that favors you. If an employer decides to change your terms favorably, they can do it by themselves. They can do it unilaterally, say, give you a promotion, give you a salary raise, that's fine. But if that change is detrimental to you as an employer, as an employee, they need to consult you, they need to seek your consent. If you have a written contract, you then need to sign a variation, sign a new contract, or at least a document saying that you have both agreed to change those terms. There are many reasons. Number one, because we already mentioned it, could be disciplinary issues. So where there are disciplinary concerns from an employer concerning a particular employee, that can be a justification or a reason to terminate a contract. But there are processes and procedures which we will discuss later on that should be followed. And disciplinary issues could be broad. It could be issues such as misconduct. It could be issues such as misappropriation of resources, theft, harassment at the workplace. So those are all disciplinary issues that can be used as reasons for terminating employment. Another reason might be poor performance. So you're employed to do a certain job. You have a job description. You have certain duties you need to be performing. If you're not meeting your performance obligations, that can be a reason for an employer to terminate you. But again, there are processes, and these are important. There are processes that should be followed before an employer can terminate an employee for poor performance. So the thing I think I want to emphasize is that even where there are reasons, because we're talking about reasons, the right process still needs to be followed. So if as an employee, you feel that there are reasons that the employer can challenge you or try to terminate you, you also do have to ensure that the right process is followed, because if that is not done, then you could still have a basis to challenge that termination. Another reason could be things like, retrenchment, for example. You could be working for an employer who decides to close shop and close down the business. That is also a reason for terminating you. But again, there are processes that need to be followed. Quite a number of avenues. The legal system is open at that point. And the legal system, I don't just mean the courts. You could go to a labor office. There are usually labor offices that are prescribed or they are set out under law. I think in every county you'd have a labor office, and you can go to the labor offices, and these are government offices, so they can assist you, try to assist you. They are communicating with your employer, try to speak on your behalf. You can also approach the courts either by yourself. Nowadays there are certain simplified processes where you can even represent yourself in court. You could go to a lawyer. So if you feel that you're aggrieved as an employee, the entire legal system is there to support you and to back you. Number one, there is reinstatement, which means you're given back the role that you had. So if you're terminated, being reinstated means that the court might order or can order that the employer gives you back the job that you have. The next one would be payment of damages or compensation for wrongful termination. So, for example, if you're terminated unfairly, there was no notice given, the right process wasn't followed, the court will make an assessment and say, for this, we should compensate you 6 months worth of salary as damages for what was done to you. So that's another remedy. Other remedies could be, for example, if wages were withheld, the court might make an order for your wages to be paid back. Those are the kind of remedies that do come to mind. forced labor is illegal. It is not just an employment issue. It is a human rights issue, and it is an important issue not just in Kenya but also globally. The Under the Constitution, there are rights that are deemed to be rights that cannot be limited. Human rights that cannot be limited under whatever circumstances. And the right to freedom from slavery and servitude is one of them, and that is in Article 27 of the Constitution. So having that as our foundation, then we can go trickle down to forced labor. So forced labor would be an issue that is unconstitutional. Employment is a relationship between two people, and it should be consensual. So in cases of forced labor, you have scenarios where someone is, you're literally being forced to do labor against your free will. So it's just not legal. There are no situations at all in which forced labor is legal. The other thing that I might mention under this discussion specifically is that it's just a few exemptions that are provided for under the Employment Act, as well as some international law instruments on forced labor. So, for example, military service would not be considered as forced labor, because you would know the kind of training that goes on in military work, or the kind of expectations that are there on soldiers, so that is specifically exempted. There's an exemption for the kind of labor that goes on in prisons. So where someone has been convicted, lawfully sentenced to serve a prison term, you will see prisoners perhaps going out to clean streets, chop down bushes here and there. So that kind of scenario is not considered as forced labor. There is a lawful exemption to that. But a lot of any other circumstances, really, forced labor is not lawful. Yeah. It's not lawful. It shouldn't be lawful. I know that it happens, and it's very common out here, but it is not lawful. And maybe it's good for people to understand or to know that, the basic premise of casual employment is that it's work that, in less than 3 months, you've done it, it's over, it's completed, you're not needed to work for that employer again, and it's a balance to be weighed here. But if you can demonstrate before court a pattern where you have worked for a total period of, say, 5 years, but on short-term 3-month contracts, in between them you're given an off period of 2 weeks, and then you come back, continue on the same job or continue with the same employer. I mean, judges, magistrates are smart people. They'll be able to decipher this, and they will be able to understand that this is, the employer is trying to navigate around legal provisions to deny the employee benefits under the Employment Act, because really the only reason then they would be doing that is to ensure that the employee doesn't enjoy benefits like leave, things like that. Yeah. Sexual harassment, to define it very broadly, I would say is any form of unwanted, unwelcome, interest or advances of a sexual or intimate nature from one person to another. So it could be things like, making passes at someone, slapping someone, spanking someone, things like that. And even sometimes more subtle or nuanced forms of harassment, like, trying to make it a condition for someone to give you sexual favors in exchange for employment, in exchange for, it could be in any situation, in exchange for business. So that's just a very broad concept of how I can define sexual harassment. To connect it to the workplace, sexual harassment does happen quite a lot in workplaces, just because of the nature of these kind of spaces. It's a common issue in workplaces, and what does the law say about sexual harassment? It's not lawful, it's not legal. The Employment Act actually does set out very specifically examples of situations or instances that might be deemed as sexual harassment. So it could be, someone trying to force you as an employee to give them sexual favors in exchange for retaining your job, in exchange for promotion. It could be just unwelcome attention that is quite uncomfortable. As an employee has is uncomfortable, communicated their disinterest, and yet someone in authority or a colleague just sort of tries to force themselves in that situation. That would be deemed as sexual harassment, and the law actually requires that every workplace that has at least more than 20 people should have a sexual harassment policy, like a policy that employees are made aware of, that bosses are made aware of about situations that are deemed to constitute sexual harassment, and just making it clear that this is unlawful. And also, employers are required to have avenues within the organizations for employees to report cases or instances of sexual harassment. And employers should also give that assurance to employees that when someone comes and reports a case of sexual harassment, there should be no retaliation, because these are risks that happen. You go and report someone in authority for sexual harassment, and you fear that there'll be some retaliation against you. Discrimination at the workplace would be any scenarios or situations where the employment environment is made in such a way that you are being put in situations that amount to discrimination, or situations that are detrimental to you on account of something that is particular to you. It could be your tribe, your gender, your race. Discrimination, it could be discrimination is just excluding you, or unfair treatment based on a characteristic that is specific to you as a person, as an employee. The way I've mentioned gender, it could be status like pregnancy, it could be health status. That's a very broad definition, but to give it some context, or to give it some kind of an example, it could be an instance where even at the recruitment stage, people apply for jobs, but one category is excluded. So, for example, certain tribes, or certain genders, certain age groups. It could be in institutions where there is promotion at the workplace, but everyone has qualified, or different candidates have qualified, but some are excluded or are discriminated against because of the kind of examples that I've given on who they are, right?